All right. This is Matt Sweeney. I'm the chair of the committee. It looks like at the moment we only have 2 committee members present. Jill, have you or Todd heard from others as to whether they're going to be able to attend? Or maybe I'm just not seeing far enough down the list.
Andres just signed on. So we've heard from a few that I think everyone's supposed to be here. I don't know that I heard back from Dr. Lewis was the only one, but I will double check my emails to make sure.
Okay. So let's start, and then we'll go through what we have and see who's here. And we don't necessarily need a quorum until we get to a vote, and I'm not sure whether we'll get to that at this meeting or not. We have, at this point, 3 sets of comments proposing revisions to the rules and to the bylaws. And they're from the Mnco team, from Drew Goddard, and from myself. And I see Drew is with us now as well.
I've just joined, yes.
Hi there.
Hello.
So let me take roll just to see, if we actually have time at this point. So Drew Goddard, yes, I know.
Here, yes.
Is Jamel on yet?
He just accepted the invitation from Outlook, and so hopefully he'll log on soon.
All right. Phyllis, have you joined us yet? I don't see. Adele? No. Andres?
I'm here.
Very good. Brenda?
I'm here.
Okay, and me. So we have almost a quorum. But as I was saying, we have those 3 sets of proposals. I think maybe the best way to start is, Jill, if you would walk through the proposed revisions of the Mnco staff, yourself and the staff.
Okay, sure.
These were sent to you just a little while ago by the director. So if you have them, you can pull them up. If you don't, if you have the set that you were working from that were sent out earlier, that should work to follow along. But Jill, if you just make sure to orient us to make sure that all of us can follow. Okay.
Okay, sure. Good evening, everyone. We'll start with the bylaws. I sent those out just a few minutes ago, and myself, Director Clausey, and legal advisor Todd Pinkley, we went over these a couple of times to make certain that the bylaws and the rules kind of coincided with the work that we're doing, on a day-to-day basis in real time. And so these are our proposed changes. So under the bylaws, under Article 3, let's see here. Under the definition, we changed the spelling. Instead of using the numbers 11, we changed that to the alphabet, the spell out of 11. So that would be on Article 3, letter A. That's the first change that we found. Under Article 4.
And as we go along, if anybody has any issue or wants to talk about anything that's brought up, let's do it then.
Okay.
A lot of these are just ministerial, and I think we can just go through and clear them through until somebody has an issue, and then we'll stop to talk about that issue. Does that work for everybody?
Yes.
Okay. All right. Go ahead.
Okay. So Article 4 under powers and duties in letter C, policy advisory was capitalized. In letter D, we took out the language, should it choose to do so, and instead we inserted, in addition to policy advisory reports and resolution reports, may establish a monitoring program. All right. And
Can you repeat that?
oh, go ahead. Sure. And let me go back. Hold on. I'm just gonna scroll back up. In D, instead, we took out the language that says, should it choose to do so? And what we did was insert, in addition to policy advisory reports and resolution reports, may establish.
Is there a particular reason why you say in addition to policy advisory and resolution reports? Because you do more than that.
I think that. Yeah, we
Hey,
do.
Jill.
Yeah, go ahead. I was gonna say, Chris, I think that was one of your changes. You
I
might
think
wanna
that-
add-
Let me put in for way of background at the moment, just when these were originally drafted, the language should choose to was added in there because at that time, there had been no decision as to whether or not the COB wanted to establish a monitoring program. So this was to pull in the language from the charter provision that recognized that power. And so it was put in there, should it decide to do so, should it choose to do so, as kind of the reservation of the right. And that's why it was worded that way. I say that purely by way of background. Go ahead, Chris.
Sure. I think the issue that we wanted to make clear, and we weren't sure that it was absolutely clear, is that it wouldn't be an either or in addition to on those things. We could do all of those things or not. I think the issue was we didn't want to make it seem like we wouldn't be doing policy advisory reports and a resolution report, but we would be doing a monitoring program. Is that kind of how you remember it too, Jill?
Yeah, I think that we talked about that. And then Todd, I think he had some extra to add to that as well. But yeah, I think that's what I recall. That's what my notes say.
And it may be that clear as it is written. We just wanted to make sure that it was clear that we could do any of those.
Mm-hmm.
Yeah.
Yeah.
They're separated by a semicolon, so I think so, but.
Okay.
But if nobody
Yeah.
has any issue, that's fine. We'll just move on to the next.
Okay.
Okay.
Well, just to be clear on that D, I mean, we want to be able to do all of those if we choose to.
Yep.
So we want to make certain that the language that is, proposed doesn't stop us from either at any point establishing a monitoring program or doing an ongoing review or audit. So.
Okay. Nobody has any issue with the language, so
Okay.
we can move.
Okay. In F, we wanted to take out grand jury because that's not how the process in Davidson County works. You have to go through the district attorney's office before you can just go straight to the grand jury. And so we kind of made that, just removed the grand jury out of the language. Because I don't ever see where we would produce findings and take it directly to the grand jury. It would have to go to the DA's office, and the DA's office would present it to the grand jury.
Okay.
Just by way of discussion, I don't think that's true.
Okay.
I think that even if a DA doesn't take something to a grand jury, that materials can be taken to a grand jury, but that's certainly not common around.
I would also note that in the charter amendment that was voted on and put in the charter, it specifically does mention the district attorney, the grand jury, or the United States attorney.
Okay.
So I think that's where that came from. I wasn't around at the time these were adopted, but I imagine that's where that came from.
Okay, well, then we'll leave it. Okay.
I hear you. I would hesitate to narrow our scope from what the charter amendment authorizes, and that might inadvertently do that. Okay.
Okay. All right. That makes sense.
So are we leaving it?
We're going to leave
Yeah,
it.
we're going to leave it.
Okay.
All right. And so I don't have any other changes under Article 4. In Article 5, I don't think there were any changes in 5. Let's see, 6, we were good. All right, and then when we got to 7, we didn't bother that one. We didn't deal anything with 7 or 8. In 9, we didn't make any changes. We didn't make any changes in 10. We didn't make any changes in 11 or 12, 13 or 14. Okay, so when we got to 14, that's our next change. So in Article 14, Rules of Procedure, Section 1, where it says board meetings, in letter A, regular and special meetings, we changed the language because special meetings, all meetings that we have to be held in metro government buildings. So we changed the language that says special meetings may, upon proper notice, be held at any time, but only in metro buildings, and may be called by the chair. So we added the language, but only in metro buildings.
Is that the only place, Jill, that we refer to meeting locations?
Well, I'm gonna let Todd answer that because I think it says in the chart. Todd, can you kind of speak on that? Where we have it, why we have to have our meetings in metro buildings?
No, I'm just saying, do we refer to location of meetings anyplace else in the rules or in the bylaws?
Oh,
Call if it's anywhere else, but I will double check.
Because it seems like it should be someplace general rather than in a place for special meetings.
Doesn't it say regular and special meetings?
mm-hmm.
The
It does.
caption does, but the sentence is only for special meetings is what
Okay.
I'm referring to.
I'm in the bullshit. Okay.
Yeah.
And that's like some of the community meetings, am I correct? We're emphasizing there.
Yeah, when we have those special committee meetings, it could be community meetings, or it could just be like how we had a special called meeting for our PRR session.
Okay.
You know, what we could do is in that first sentence where it says at least, well, again, that's just regular meetings, so that doesn't help either. You might put in a separate sentence at the end of that section that says all meetings shall be held in metro-owned buildings or something like that. That might be a better place to put that.
Okay.
Now,
I like that. Mhm.
when we get to Drew's proposed changes, he wants to change that section. So we just have to remember to keep that in mind too.
Right. So maybe it should just be an additional sentence since we might change the language around. Yeah, that makes sense.
I think so.
Okay.
At the risk of complicating it, do we mean that to be the case just for board meetings or down in D for the committees and task forces as well?
Both.
If I thought so, if you want that D may be the better place, and change the caption to open meeting, comma, recess and location, or have a separate location section. I just offer an option. I'm not wedded to any of it.
No, I think that's a great place for it.
Mm-hmm. So instead of putting it in A, we're going to put it in D.
Yeah.
Okay,
Yes.
that makes sense. And change the title to D, to open meeting, recess, and locations.
Makes sense.
Yeah. Okay, yeah, that makes a lot of sense. I like that. Okay.
And what are we going to call that caption then? Are we just going to call it meetings? Meetings and locations, meetings and recesses, or
Recesses.
and take out the word open? Does that work?
Meeting, recess, and locations? Or just meeting and locations? Are we talking? Let me see what this is. All meetings are subject to the requirements of adequate public notice. Or maybe recess. Yeah, maybe just
Meetings and locations.
meetings and locations. Yeah. Hey, Chris, are you putting the changes in as we talk, or should I go ahead and, I don't want to mess with with the document.
I am making the changes as well, but I think Todd's doing it as well. He's doing it on the screen. So he and I will both I'll be doing it on my end and he'll be doing it on the screen.
Okay, perfect. Yeah, and I'm taking the notes. Okay, thank you.
Sure.
And then eventually, you know, we'll just have to reconcile the 3 different sets of documents that we're working on.
Right.
Okay, go ahead.
Okay. All right, so let's move down. Specially called meetings, electronic meetings. We are moving to, we don't have any changes in that. Under it. So Article 15 is ethics. We don't have any changes in that. We don't have any changes for Article 16 budget, 17 amendments, 18 filing, interpretation, servability. I think that is it for us in regards to the bylaws.
All right. So let's go through your rules then.
Okay. All right. Let me get to the rules page. And by the way, Dr. Hildreth said that she's tied up for about another 30 minutes and she should be joining the meeting.
Okay.
All right, so under rules, we did have more changes. Let me get to those. All right.
And Jill, while you're getting to yours, I noticed one thing that we changed on the bylaws that we might want to do on the rules as well. And Todd, you're actually right on it, is section 1 under the definitions, B, the board, instead of having just a number, we would write in 11.
Oh, I think I mentioned that earlier.
Yep.
Yeah, 11. Spell it out, yeah. Okay, I see that. Okay. All right, let me see. I am on, okay. Section 2. All right, section 2. So under the letter A, complaints and the initiation of investigations. Under the letter, I'm sorry, the number 2, we have made a change to the 3rd sentence. So we want to take out, so I'll read it. CLB will establish an accessible system for receiving complaints by as many means as practically available, including in person, by telephone, by mail, by faximile, by email, website, and by other electronic means. And we want to take out the sentence that says, recognizing that as a newly created entity, all means might not be available initially, because that doesn't apply any longer.
Okay. So all those means are now available.
Yes.
Okay. And do we use them all?
No, we don't really get any fax.
But somebody can submit one that way?
Yes, they can fax it to us.
Okay.
But we don't, now this is the tricky part. We don't really advertise our fax number, but if someone called in and said, well, can I fax it to you? We have a fax number for them to, each person has a fax number that they can have someone fax a complaint in.
Okay.
All right, so the next category is, let's see here. All right, in number 6, there were, down in the kind of the last few sentences of that paragraph, it says, in making such a request to the MMPD Chief of Police, the director shall inform, and we're going to take out him and put in the chief of the basis for the complaint. And then we're going to go down a few sentences and say, and shall explain the facts and circumstances causing the director to believe that the officer's continued presence on the job may be detrimental to the department. So we're going to take out the 2 hymns in that particular paragraph. All right. All right, we're going to scroll down to, let me see what section this is. We'll scroll down to under B, intake investigations in letter 4. The B section, we're going to add the director. It says the director or assistant director will review each complaint to determine whether the COB has jurisdiction. Because of course, Assistant Director Clausey or whoever is in that position is over the investigations. And we're going to take out at the very end of that paragraph, it says the director will give written notice of each investigation undertaken, including a copy of the complaint, or if not in English, a translated complaint to the OPA. So we want to remove that as well.
Okay. And are we putting in some other notice provision in its place?
No, we're not. They get notification because we have to coordinate through the OPA and let them know what officers that we need to assign to cases. That's a part of the MOU. And, you know, they set up the interviews, and there isn't any other type of notification that that we have to give them. We notify the officers and their supervisors.
But why wouldn't we want to notify OPA?
Well, I think that one of the things, I think that notifying OPA in the beginning of our investigation, I think just doesn't give us the kind of independence that I think that it's okay to notify them after we have started the investigation. I don't want to, they don't share with us when they're investigating cases, and I just don't think that we should have to share the beginning stages of our investigation with them.
All right.
And at some point, we do come together and discuss it because we're asking for records and things of that nature. So there is some form of notification. I just don't necessarily feel like it should be added in our rules as a rule that we have to do that.
Okay, let's move.
Okay. In C, it says investigations. We want to take out the word will and add may be stayed if a criminal investigation is undertaken.
Okay.
All right. In F, we changed that significantly. So let me get to it. Hold on one second. So in F, we changed the structure of the sentence. So In certain cases, so we changed it to read, in certain cases, except in those alleging use of excessive force, serious bodily injury or deaths in or related to police custody, the COB may offer an opportunity to participate in mediation, restorative justice, or other non-punitive remedies in response to allegations of misconduct in a complaint. And what we did there was we added the language that was in the MOU, and we inserted it in this particular paragraph so that they read the same. And of course, we took out the other stuff that says in all cases undertaken by the COB, except those alleging excessive force, serious bodily injury, or in custody deaths, the COB may offer mediation, conciliation, and or restorative justice programs. So we took that out and included the new language, and that's the only change to the sentence.
Question for you. That first sentence, I'm reading that. Hold on a second. Excessive force, serious bodily injury or deaths. I'm reading that serious bodily injury or death is only related to in police custody. Is that correct?
No, in or related. Serious bodily injury or deaths.
If they shoot into a car and kill somebody, I would read this provision not to apply.
Well, that's the same language that we used in our MOU, then I didn't take it as that. So if we need to change it slightly, then we can change it.
Well, I don't know if the in or related to police custody appears in the MOU in a different way. But,
no, that's the actual language that we took from the mediation portion of our MOU.
How do other people read this?
I read it the way you do, Mr. Drew.
All right. Well, we don't want to keep, we want to be able to, well, we don't want to limit ourselves in it for sure. So we can actually wordsmith it. If anyone has suggestions, I would.
The one thing I would chime in about is when an officer is using that level of force, it's to take the person into custody, and I think that's kind of along the lines of in or related to a police custody. So if I was trying to use a force to stop the person so I could take them into custody, that was kind of I think that was what I was thinking. But if it's not clear, we might want to clean that up.
Mm-hmm.
I don't think that in or related to police custody tells us anything else, and that it limits serious bodily injury or death. So I would, in this context, without looking at the MOU and what the MOU says or what else the MOU says, I would think that we would just want to take out that language in or related to police custody. So that we need excessive force, serious bodily injury or deaths, the COB may, blah, blah, blah.
Okay.
But I'd like to hear what other people have to say too.
I agree.
I agree.
Andres?
I agree.
And Jamel?
I think I agree. I'm not sure. I'm still trying to sit with it and think it through because I'm not sure if this changes anything, or I might be overthinking it, but it feels like it narrows it down, but I could be wrong.
As I would read it in the context here, there would be certain situations of serious police injury or death that is allegedly caused by them, where it could still go to mediation if you left the language in. And that the only serious bodily injury or deaths that couldn't be mediated would be those that were in or related to police custody.
Yeah, I think I understand. What I guess I'm getting hung up on is that if an officer is committing like bodily harm, injury, or death, some serious form of excessive force, would they mediate that, or would there be something that's like would mediating taking them possibly losing their job off the table? That's why I guess I'm getting hung up at that differentiation. Because
well, when we originally discussed the provision, there were certain matters that were so serious that we didn't think that they should be mediated, that they should go through the full and investigative process and resolution process in consideration by the board. And among those were allegations of excessive force and serious bodily injury and death. Those were things that we took off the table.
Right. And so by taking this out, how does that change that dynamic?
What this says is that, as I read it, it says that unless serious bodily injury or death occurred during police custody, then other cases of serious bodily injury or death could be mediated.
Gotcha. Okay. I think I understand. I'm just trying to sit with how this plays out in real time. So that's my only hesitation. That's why I say I could be overthinking it. That's why I'm just trying to sit with it and like work it out how this will play out in real time.
Okay. So, I mean, I think the consensus, Jill, is to take that language out.
Yeah.
And then we should go back and look at the MOU and see if we need to wordsmith anything on that and ask for a minor revision to that.
Okay, that sounds good.
Okay.
Okay. So you want to move on from F?
Yes.
Okay. Any other questions? Brenda, did you have one? No. Okay. Uh-oh, hold on. Let's see, where am I? Page 4. All right, here we go. All right, so the next section would be under C, proposed resolution reports.
Yep.
All right. All right, so under 1, what we did was I talked with the team, the executive team, and we discussed, since we have such a backlog of cases, how do we get through these cases and move to get these to the board so that we can, clear out our backlog? I think in the last meeting I said I had a pretty ambitious schedule, and that is to try to get as many of the cases, the PRs, to the board within the first quarter, because they have been kind of lingering on and we need to get them resolved. And so we talked about it and we looked at what other cities were doing across the country. And it seemed like the best practice across the country is that the legal advisors or the legal teams in these different oversight boards were using their legal advisors or their legal team to help create and execute the PRRs. And so we changed our language a little here to show where Mr. Pinkley and I could work together to move through the cases that we have, and of course let him review them because he is the legal advisor, to make sure that they're legally sound before we present them to the board. So the language, this is what you're going to hear when we read section 1. So in section 1, we're proposing the change to read like this: within 30 days after receipt of an investigative report, the director, in concert with the legal advisor, will prepare and submit to the board a proposed resolution report with factual findings based on the investigation. And so throughout this paragraph, we were going to change that language. But before I read it all to you, I just wanted to see if you guys, how you feel about the accepted change.
Makes sense to me, whatever you think your appropriate staff allocation is to work with you.
All right. So I'm going to reread this one. So in 1, it says, within 30 days after receipt of an investigative report, the director, in concert with the legal advisor, will prepare and submit to the board a proposed resolution report with factual findings based on the investigation. The director, and then we're going to insert, and legal advisor shall ensure that the investigation is thorough as necessary to reach reliable and complete findings. Complete findings, and is objective, fair, impartial, and free from political influence. The next sentence will read, the director and legal advisor will consider all relevant evidence. And then if you go down to the next sentence, it says, including circumstantial, direct, and physical evidence, and will apply a preponderance of the evidence standard in making, instead of his, we're going to include any findings. So we're going to remove his and put any. And then if we go down a few sentences, where the director is in the middle of the sentence, it says, the complainant, an accused, or a witness, or whether the person is a law enforcement officer, nor will the director, legal advisor, or investigator disregard a witness's statement merely because the witness has some connection to the complainant or accused. So those are the proposed changes for section 1. Any questions?
No.
Okay. All right. And so we did have a change under H, which was the grand jury, but we decided based on your wisdom to keep that grand jury in there. So letter H, there was no change. All right. In D, this is where, and I think that Mr. Goddard also had some concern with D. We wanted, like, the part that's in this section kind of midway, it says, it talks about the permission. So it used to say permission will not be granted regularly, but the board chair may grant permission for brief comments by both if requested by either. I thought that to be pretty arbitrary, so we decided to take out where permission will not be granted regularly. And it also, that was one of the things that came up when Mr. Jack Bird, attorney for the FOP, came and spoke with us as well. He wanted some clarity on that as well. So
why don't we hold discussion of this?
Okay.
Until we get to Drew's, and then discuss both of those together.
All right, that makes sense.
That's fine.
Okay. All right. I'm scrolling through to get to the next section to see where our changes are. In section 7, which is on page 11, under letter B, we decided to change where it says request for the assistance of an interpreter will need to be made at least 5 business days before a board meeting. It's really hard to get an interpreter within 3 business days. I actually would have liked it to be more days than 5, but 5 I think is a minimal because, you know, trying to get someone scheduled for interpretation services, I think definitely we have to be proactive with that. So we wanted to change 3 to 5. And let's see here, section 9, 10, and I think that may be all of our changes.
I think we got the grand jury again.
Yeah, I see that. I just passed that one. We're going to keep that one. That was in, the grand jury was on page 14 in under number 9. We're going to make certain that that one it stays included. And I think that's it. Of course, that's I think that's all of our proposed changes to the bylaws and rules.
Okay. So let's go through Drew's set.
Wait a minute, I think you changed in budget and finance he to something else.
Yeah, I was just about to jump in on that.
Oh, wait a minute, did I miss it?
Yeah, on section 12, budget and finance, the 3rd line says COB, comma, with he, which speaking of the director, and I thought we would just put which shall be presented to the board, which shall be presented.
Oh, I see that. I'm sorry. Yeah, I passed that. Okay.
That's an easy one to miss.
Yeah.
But it's important because you're not a he.
Okay. All right.
So it still will be revised a little bit further, right? Which shall be presented.
Correct.
Okay. Which shall be presented. Okay, got it. I did skip over that one. Oh, section 4. Okay. Anything else? Did I miss anything else on there? I don't think so.
Just changing the chair's name.
Right. Thank you. Okay.
It's a team.
Yeah, I think we're good on that. So ours is done. Thank you all for that. And we are moving over to Mr. Goddard's.
Yes. So what I would propose on this is we will make those proposed changes and put it into another red line.
Okay.
And there'll be another committee meeting that will look at the final document in its final language with all the red line changes that then can be voted on by the committee and approved or further revised.
Okay, perfect.
Okay. So let's look at Drew's proposal.
Okay. And before we go there, did anyone have their hand up? I don't think so. Okay, so we'll just move on. Okay.
Okay. Drew, do you want to start by talking through on the bylaws?
All right. Let me scroll down. My first change was to add some language to the definition of misconduct. It'll show up in both documents to have the exact language that is in the charter amendment that we operate under. And that defines misconduct as improper behavior by an officer employee against members of the public is the language I propose to add, which violates MNPD policies, criminal laws, or civil rights. As I read our jurisdiction, and again, I'm just being an anal lawyer here, trying to make it line up with the charter. We don't have, that may be redundant, we don't have jurisdiction over embezzlement, theft, whatever within the police department that affects the police department and not the general public. So that's the change, to add the against members of the public.
We did have I don't remember whether the language against members of the public was intentionally omitted or not.
Yeah, Todd said he had, Todd, can you remember, can you jump in and tell us what you recalled from that?
And this is based on, about a year and a half worth of memory. So I may be misremembering this, but I feel like there was a discussion about adding members of the public for instances where a complaint may come in from one MNPD officer against another MNPD officer.
We discussed that in a context that we never resolved, but I don't remember if we left the words members of the public intentionally out, but we never resolved whether a police on police situation could involve a member of the public. So if you have an abused spouse, allegedly, who was or wasn't a member of the police department, whether or not that was a member of the public.
My only thought was, whatever the answer is, it'd be the same under the charter versus here, but I'm happy leaving it if there's any concern.
It would. But, and I don't think that's why that language wasn't in there, because I think we understood that we only have jurisdiction over members of the public. But I do know that we discussed that extensively, and we decided that that's a matter that we may or may not have jurisdiction over, and we just have to address it when it came up.
Well, in light of your recollection of that, what's your best recommendation on whether we plug this in or leave it as is?
I don't think it makes any difference because it is what it is. So
if it doesn't make any difference, then we don't need to make the change. That's fine.
So I think it's fine to put it in there. I think any language that's consistent with what the charter provision says is fine.
Okay. All right.
So being an anal lawyer is fine.
Okay. All right. I just didn't want folks to do this, think we have more authority than the charter allows, and not check the charter as part of it. That was really the point. The other comment in that paragraph was we define various terms capitalized and use them capitalized throughout. For misconduct, for some reason, the word misconduct is used a number of times later, not capitalized. And that can create confusion of whether that's generic misconduct or specifically defined misconduct. So I would ask that Todd or someone go through and anytime the word misconduct is used and it's clear we're talking about this, to change that to capitalization. That sounds really unimportant, but it can be important in interpreting these, I think.
Okay.
So I have one question. So just to some clarity of what we just spoke about regarding improper behavior by MNPD officers. So if an MNPD officer who is employed comes to us with a complaint of, let's just say, harassment or some other form of misconduct that's being alleged, are you saying that the charter doesn't give us provision to take that complaint and investigate it?
Your legal advisor is going to have to advise you as to whether that's a complaint by a member of the public.
Okay.
Or against a member of the public.
Yes, actions against a member of the public, so a complaint by a member of the public, but yes.
Okay.
Because that's our jurisdiction. Unless your lawyer advises you that language, members of the public, is what's called surplusage. How do you pronounce that word? And
surplusage.
Surplusage, and therefore it's not actually restrictive. But that's a legal question.
Okay.
That your lawyer would have to advise you of, and might be something that would have to be considered by the board.
Okay. All right.
But the intention, if we put the language in here, I want to be clear, is that we still have the full jurisdiction authorized by the charter. It is no way meant to be more restrictive than the charter if we put it in here.
Right.
Okay. Sorry, go ahead. Go ahead, Mr. Goddard.
Okay, next thing was on page 3. Towards the bottom of page 3, we had a provision allowing us to develop rules for a certain purpose. And I simply want to recommend we change that to say we have the authority to adopt rules, including for that purpose, that we can adopt rules for whatever we like that's legal. Clearly, we think that we adopted a bunch of rules for other stuff, but that's just cleanup.
Yep.
I hope that's just cleanup. Matt, give or Todd,
Nope, makes
any
sense.
contrary thoughts? Okay. All right, more substantive, wouldn't take much. At the bottom of page 8, there's a provision on public statements. And we have language that says when circumstances require public comment from the board or an issue or event about which the board has not yet taken position, the chair or executive director may respond. And I suggested, the main intention would be to have a conversation amongst this group. I suggested, does it make sense to add, provided the response notes that the full board has not yet considered the matter? So it is clear if a statement's made, whether that is one the board has considered and adopted, or is one it's employed and elected official is making in the absence of that by the board.
So Jill, I think part of this, it's important to you as to
Yes.
what matters do you feel in your day-to-day service that you should have to get either advance approval or after the fact approval from the board before you say something about anything? Is what this is proposing is that whenever you make a comment on something, that you say, but the board hasn't passed on this issue.
Well, I didn't mean quite that, Matt. I may have misworded, but that's true. The lead-in should be the only official spokesperson for the board. This is when someone is speaking.
But the executive director, in a sense, always speaks for the board. She's our principal agent.
I hadn't focused on that. Okay.
I don't think it's necessary,
Okay.
and I don't think it's practical. But I'm wide open to discussion.
I think we should leave it as it is.
Okay.
Any other comment on it?
Andres?
I agree to leave it as it is.
The director to have, approval from the board before speaking. Do you want to have that approval from the board before speaking, or say, I don't have approval?
No, I don't think. I think the director should have the authority to say things, but I think the director is capable of understanding that commenting on something may call into question our impartiality later, if that is a case that's going to come up or that may come up. And I think that has been our, maybe it's unstated there, but we just in general don't comment on things that may become a conflict of interest for us in the future, because we don't want to regret something that we said.
Makes sense. Okay. I'm fine with that.
All right, so we won't make that change.
Yeah. All right. Next change was on page 10. When we're recessing a meeting, and this is just, I hope to have something here that I understand to be the legal requirement. My understanding, and I've done a bit of work in open meetings, is that if you have a noticed public meeting and you decide to recess it, you have to announce the date, the time and place where you're going to reconvene. Otherwise, you have to renotice the whole meeting. That's the whole point of a recess. So I just suggest we add, maybe where it says now, maybe recess to a later time, to say maybe recess to a specified later time. Just to make it clear that that's part of what you have to do if you're going to recess a public meeting.
Yes,
But I don't,
where was that again, Drew?
it is on page 10 in D. D is in David.
Okay,
Section, yeah.
yes. You had something before that too.
Well, what did I have before that?
Well, it's kind of a
it was,
combination with E below.
I'm sorry. Yeah.
Or F
I
below.
was going to wait till E for that either
Okay,
way.
okay, go ahead.
No, okay. So that was a specified thing. Todd, is that your understanding on recesses, or have you had occasion to look at that?
Yes, I believe that's correct.
Okay. Okay, that's what that one was. If anybody has concerns. All right. The other thing that Matt was referring to is we've got special meetings discussed in A, regular and special meetings on page 10, and then on the following page in F, specially called meetings. First of all, I'll ask a question. I'm not aware of any legal distinction between a special and a special called meeting. I understand those to be the same thing.
Yes.
Okay, and if that's the case, I think it makes much more sense to have whatever the rules are for those be in one section.
The only reason I agree there's a problem between the two sections, but I think that the first part has to do in A with kind of the ordinary and regular process, where the chair can call a regular or call a special meeting. And then F is basically the situation where board members have problems with what the chair is doing, and therefore by themselves can call a special meeting.
Okay, well, in that case, my concern is limited to the last half sentence of A, because it talks about the secretary calling such a meeting at the request of any 9 members of the board. Okay.
Agree. And one thing that I was thinking of was to make a change to the second sentence so that it would read as rewritten. Special meetings may, upon proper notice, be held at any time and place, called by the chair or as provided in F below.
That's fine.
Okay.
That works.
And then F have the provision for the meeting that gets called by members as distinguished from the chair. Does that then work?
Yes, that works fine for me.
Okay. Chris, do you catch what that language change is? Are you still playing draftsman with this as well?
Well, Todd's doing it on the screen, and I've been following him and making sure he and I are in sync. So yes.
Okay.
Okay. That's what I had on bylaws.
Okay. And let's go to yours on rules.
All right. The first one in K on page 1 is the same against members of the public language. Whatever we decided there.
Okay. Nope. We kept that in.
All right. Page 2, section 2, A1. Everybody can follow that.
Hold on, Mr. Goddard. Andres, did you have your hand up? Did you want to say something about it? I'm sorry. I just saw his hand up.
No, sorry. That was from before.
Oh, okay. All right. Sorry for the interruption.
Not a problem. Middle of page 2 we moved to the rules now. 2A1 says, additionally, director may initiate a misconduct investigation based on media reports, other public information, or request by the board. And this is a footnote for me to ask the question, are we not allowed on information that's submitted and not public and confidential to initiate a request, or does it have to be public information? I wonder why the word public was there.
I don't know that it was there for a special purpose. I think it was just making a distinction from media. you know, as we were talking about social media and things like that. And so it just came under public information. But no, I don't think that it makes a difference really what the source of that information is.
Okay. Well, I would suggest dropping that.
Okay.
And then there's language in the, if anybody else have questions or objections to that, concerns? In the next paragraph, there's provisions that if you don't submit the information properly, it won't necessarily be considered a complaint. And I suggested added, providing the COB at its discretion may initiate a misconduct investigation based on any information received. I mean, the reason if something comes in, it's not the proper form, whatever else, but it raises enough concern you want to initiate investigation, I think we should be able to, staff should be able to do that.
Well, we had concerns about that.
Okay.
So that we could properly monitor information that comes in. And just because somebody sees somebody on the street or mentions something to somebody, you know, that nobody thinks that that's a complaint. So that we have a formal process that gets initiated either by a person who has an issue or by the director, but that it's done through a formal process.
All right. I defer on that one. Anything?
There isn't a statement in here, maybe it's in 1A1, that the director has the authority to initiate.
Okay. All right.
So I would recommend not including that language.
I'm fine with that. Page 3, number 7, currently reads, the last sentence currently reads, all personnel employed by the COB will maintain strict confidentiality about COB matters at all times, And I suggested adding, except as otherwise required by law, because a lot of what we have would be a public record, I think, in certain cases, and certainly subject to subpoena for things potentially.
Yep. Agreed.
Okay. Any concern about that? This is not licensed to go publish all that stuff, but just the qualification. All right. More substantive. Oh, so this is pretty substantive. Top of page 7. This is whether the parties, either party or both parties, have a right to speak for 10 minutes if a resolution report has been presented to the board. Right now, it's got language about 4 good calls shown and this and that. And I had 2 thoughts. One, I think it's fine to have somebody want to talk for 10 minutes and they're a party to that and it's come before the board to have that opportunity. Second, if we have to have a discussion about what is or isn't good cause, you'll spend your 10 minutes hearing lawyers argue about that rather than the substance of it, I'm afraid. So I would suggest just taking out, have a right for folks to talk for 10 minutes if they want to, if we've got a resolution report coming to the board. Not lots and lots of folks, just the 2 parties.
And we had a long discussion as to whether or not we permit people to speak in general, with the concept being that these reports were going to be as thorough as possible, and we weren't going to be rehashing the reports from the viewpoint of either of the parties. And that therefore there probably were not going to be many situations where it would advance the process for people to speak, but there could be some. And so the provision, when it was included at that time, was included in there as kind of a fail-safe in order to help us make sure that we don't miss something. But I just say that purely by way of background.
All right.
So I throw this open to a revisiting of this issue and whether or not we want to have just an open policy that every time that there is a report that comes before the board, that we want and we should expect that both parties will come and speak.
Well, I did want to jump in here. I think that this was the issue, and Chris, you can help me if I'm mistaking or misquoting what Jack Bird mentioned regarding due process. Do you recall what he said in regards to this?
I do. And I think that was the issue and kind of the thing that we've talked about, the board's talked about, and that we've talked about as well, is this isn't really a due process hearing. It is, and therefore the due process wouldn't necessarily, well, it wouldn't apply. But on the flip side of that, as giving everybody an opportunity just to have their 10 minutes may or may not be a problem, as long as everybody understands that this is not a due process hearing. The due process will come from the Metro Police side if they follow our recommendations.
One thing that I think is important as far as the process by which the investigation is done is for the both parties to have a full opportunity to state their case to the investigation.
Right. So are you saying, for instance, if one party decides to show up, but another party doesn't, is that what you're saying, Mr. Sweeney?
No, what I'm saying is that in the example that you've talked about with the officer, that an officer shouldn't be charged and have a charge against them without feeling that they had an opportunity before you, meaning Mnco, in the process to make their defense. So that they could give you evidence, they could give you information that they think, absolves them. Because if they get to speak to us when they come, they're not going to be able to put on new evidence. They're not going to be able to give more information. All of that is done in the package. There's nothing, this is not designed in the way when the board looks at it to receive additional evidence.
Right.
No, I'm not saying that we shouldn't allow people to speak, but it needs to be really clear to people that they understand that this is not a need to make their case and present evidence and present witnesses and all like that. Because that's not the model that we've selected for disciplinary matters. That model is to have all of that occur before it ever comes to the board.
Yeah, and just on the flip side of that, I think that we have to be careful when we allow people to come and speak, because you have aggrieved parties. If there was something where, if there's injuries where a complainant feels that this, repeating this in public especially when we're doing it in person, I think that it could inflict trauma and cause, more harm than is anticipated. So I think we really need to be careful when it comes to this. Mr. Gooch has his hand up.
Yes.
Yeah, thank you for that, Director. Yeah, I think that's, if I remember correctly, I think that was the reason why it was written in this way. Where people could get notice that the other folks were coming, just in case, just to try to avoid and also plan for situations where people may want to come and talk to us, but it might be like traumatizing or triggering to be back in the situation. So I want to say, like, that was the reason why early notice was given, because it would allow us and the staff and the board to both foresee what's coming and also plan any type of procedural things that need to be planned beforehand.
So there are kind of multiple questions that are built in on this. And that's number one, is it the routine course for people to speak? And then as a sub part of that, do they need to tell us that they want to? You know, for example, the one matter that we've gotten so far, people got notice, but they didn't want to come. They didn't ask to come.
Right.
And so, you know, I do agree for the reason that Jamel just said, that we still want to have people, you know, somehow inform us that they're going to come speak, even if we make it speak as a matter of right. That they get notice, and then they tell us if they want to or not. But what's everybody's thought? Change this and make it automatic, or keep it the way that it is?
And Matt, we've dropped the will not be regularly granted language, right?
We haven't done it yet. Because again, it was designed as an exception. It was not a matter of course. It was that they have to show us that there's some particular.
I thought Jill's comment was to drop that language.
It was, but we just left that open for discussion.
No, I'm sorry. Okay, well, I think I'd feel fine if we just drop that language, like the executive director recommended, in light of all the discussion I've had. But I would still support that drop.
And along with reason or good cause, or leave reason or good cause still there?
Personally, I would drop it, but having heard the history that is there, and that unfortunately with the Open Meetings Act, I can't have discussion about it before meetings. I would leave that in personally, but it definitely needs to be a group decision, and I wasn't part of the history.
One of the other things that I've been thinking about, and it came up, for instance, with the other case that we had, is what happens when we, for instance, when we go back to having meetings in person. If we had a complainant, a grief party who has had a traumatic experience. I had spoken with Andreas about this, I think, a while ago. Like, how do we, what are our provisions in, maybe separating them? How do we go about the function of having people in a room together? And where, I don't think that we actually have the function or the wherewithal to, separate people and, all of this. As I'm thinking through this, it may just be best to have written comments, and I don't know if I have the authority to say that, but then neither parties have to show up in person, and we can just read their statements, and it might just cut down on a re-victimization or traumatizing someone or triggering them.
Brenda, what do you think?
I'm thinking that a person should have a right to come and speak if they choose to do so. But Jill brings up a good point in terms of traumatization. So that's how I'm feeling about it.
Okay. Andres, what do you think?
Yeah, I agree with Ms. Frost. I don't think logistically we could separate them or not allow one party to be inside the meeting room while one is. So it's difficult, but it would be ideal to have a response in writing. I think that they should be allowed to speak if they want to.
Okay. Jamel?
Yeah, I am all for clarity, transparency, and communication, but I do want to hold what the director just said and do want to give that more thoughts around how we can do this in a way where it doesn't put people at risk.
Well, that's going to be an issue for the staff to determine, and how the staff is going to handle it, assuming that we make it as a matter of right. And one of the challenges that they're going to have is they might not know until it becomes evident at the hearing. But that's true both in the situation as an automatic right to speak and a granted right to speak. The only difference is the granted right to speak will probably be less frequent.
I certainly am sympathetic with and very much agree with all that's been said about those that would have issues and trauma and whatnot speaking. One thing occurs to me is a granted right to speak may have folks that want to speak not making the effort to try if they think they don't have a right to. They may be told no, don't want to come down and deal with that. I don't know.
Well, the majority position is to make it automatic. So I would suggest that Chris, that you and Todd work to revise the section for our further discussion when we see everything as a new proposal. To make
Okay.
it automatic, but with people still being advised in advance and them being asked to advise us. So the only thing that I wouldn't make automatic is they have to tell us that they want to.
Right.
But if
Yes.
they ask us, if they say that they want to, that then they have the right to.
Right.
Jamel has his hand up.
Yes, sir.
Yeah, so I would like to let's stick a pin here and make sure, like, and I'm just saying this for myself too, and make sure like we spend some time here with the whole board, because I think it's super important.
Good point.
Me too, but as a practical matter, Jamel, when we come up with rule provisions, the committee looks substantially to us. But from everything that I've heard, this is the only provision so far that probably needs, some deep discussion, maybe at another committee meeting here and by the board. But so that it goes to the board and say, we recommend these changes. There's no issue as to any of them except for, and then this and whatever else, and then we dive deeper with that.
Yeah, absolutely. And just to center even further, I guess what I was thinking is I think that there's some assumptions or some foresight that we didn't have when we created this.
Yeah.
So it sounds like in either ways, this could be a potentially not explosive situation, but a situation that the staff may not even be built in a way to be able to hold this. So it feels like whoever the sitting board members are, when a situation occurs that needs this right here, will be like needed. So I was also thinking about like literally talking all of that out.
Yep. I mean, I think they're probably, just as a practical matter, that there's going to be more time and opportunity to talk it through in this committee than the board will grant to talk it through. So I think that when the committee meets again, it should focus not only on going through and blessing the other changes, but for everybody to think hard about this one and to be prepared to, you know, talk it through extensively further. And then to take it to the board and then have the board do that as well with the insights that the committee can bring to it. Does that seem to work for folks?
It does for me.
Yes.
Yes.
Okay. All right.
I ended with a bang. Apparently, that was the last one I had.
That's the last one you have? Okay. And then I've got a couple small things that are cleanup. In Article 7, Section 4 of the bylaws, we have a provision in there that we talked about last year with the terms of office ending before the election cycle, so that we have people that, you know, were taking office in August who theoretically may or may not be on the board for half of their term because board members can switch into January. And so I've proposed editing this section to provide that the board officers who would be elected in August of this coming year, instead of serving for 1 year until August of the following year, they would serve until January 31st of the following year. So they would, instead of serving a year in that officer position, they would serve a year and a half in that officer position. That would then sync up the cycles going forward from there to a January date. And so the question is, do we want to sync the terms to a January date? Or are we comfortable with the way it is now that they end in August?
I think it makes more sense to do it in January. That way, for people, for instance, who got elected in this August, August of 20, and if they don't if they don't come back, for instance, like Ms. Ross, then she would have only served in her position for 4.5 months. And so I think it makes sense to sync it up to January so that people get the full totality of the opportunity to serve in that position.
I agree.
Okay. Jamel?
Yeah, I agree as well.
I mean, I was gonna say I inclined to go with what the director just mentioned as well.
Okay. Drew?
Yes, I agree.
Okay. Andres?
I agree.
Okay. And then the other cleanup would be the way it's written in there now is it's a maximum time that somebody can serve in office of 2 years. With this change of somebody getting to serve a year and a half, that would mean that somebody who gets elected at that time couldn't serve a second term. So I would then change the language in that same provision that you can't serve in a particular office for more than 2 years to make it more than 3 years. Does that make sense?
You could say that, or you could say no more than 2 full terms if you really want it to be 2.5, but I'm fine with either one.
That's probably a better way to put it, is 2 full terms. Thoughts?
2 full terms.
Okay.
Yeah, 2 full terms is very clear. So people, yeah.
I agree. I think that's clear. Okay. And then there's some other just minor language in there that clears the same thing. And I'll send that language over to Todd to pick up. And then the other one is for terms of office for committees. It's a little unclear, the language that's in there now, where it says that each committee or task force member shall be appointed to serve for a term of no longer than 1 year. And then it states that committee members and task force members may be reappointed on a year-to-year basis. So what I would suggest taking out is the language no longer than. And so that it would read instead, each committee or task force member shall be appointed to serve for a term of 1 year. Committee members and task force members may be reappointed on a year-to-year basis, which means you could serve on a committee forever.
Mm-hmm.
What's everybody think?
I'm agreeable.
I'm fine with that.
Yeah, I'm fine with that.
Same here.
Okay.
Yes.
All right, and then does anybody else have anything else that they want to talk about?
I just had 2
provisions. Yes.
I just had 2 things to maybe bring up that I kind of noticed while we were going through.
Okay.
In the public statements section, for example, when we released the immigration report, and Mr. Martinez was chairing that particular policy report. When that report went public, would it make sense to have some kind of exception for chairs of policy reports or other committees to be able to provide statements about their respective report?
Yeah, I think that makes sense. Is everyone following what he's saying?
Well, I don't know. I mean, when Andres spoke about that, he was chair of the board, right? Wasn't he?
No, he wasn't. And so to give you a little background, so when that report came about and the news was asking for comments about it, this provision only allowed for the chair at the time and myself to talk about it. And that particular advisory report was very specific as it pertained to issues of immigration. And so what Todd is saying, and we had this discussion, is that because Mr. Martinez was he is the person that wanted to move or that made the request to do the policy advisory. What we would like to see is that the chair of the committee or the person that made the proposal should be able to make a comment regarding why they wanted that particular, policy advisory to go forward.
Well, I don't think that there's a prohibition now from that standpoint to say why somebody requested the report, because they're not speaking on behalf of the board, they're speaking on behalf of themselves. As far as speaking on the advisory report itself, I think maybe the better way is to let the chair authorize somebody to speak on behalf of the board. Because once a policy recommendation is made, it's the board's recommendation. It's not an individual member's recommendation.
All right, but the language right now authorizes the chair to designate someone only if the chair and executive director are unavailable.
Right. So
Right.
I think the better way is to revise that language
Yes.
rather than have something broader that somebody who requests, a policy advisory can speak. And that gives kind of a more flexible sort of approach where there might be a number of different matters where the chair thinks that it would be better for somebody else to speak.
Yes, I agree with that. That's great.
Okay, Todd, so if you incorporate that provision in.
Okay. And then my only other one is, if I can find it.
Well, while you look for that, Todd, Mr. Andrea has hand up.
Yeah, I was just going to agree with that. I think the chair should be able to decide who makes the comment on the policy advisory report. And I think that follows the rules that are already there, that the chair decides who speaks on behalf of the board, or it's going to be edited to say that the chair can designate someone to speak, even if the chair is present or able to speak on it, right?
Yep.
And I'm sorry, go ahead.
No, I was just going to say Matt may need to explain these rule changes so we were headed here, but that's okay.
What do you mean?
I mean, if the board chair doesn't want to explain why we made these rule changes, he can designate you, was what I was saying.
I'm going to be gone.
No.
There.
Sorry, I should be quiet. Go ahead, Doc.
So my other suggestion or just comment would be for Article 17 under amendments. Since these are bylaws, Robert's Rules recommends a 2/3 majority to amend bylaws. So I just wanted to propose that to the committee. I think when I spoke to Alex Dickerson, who was the original attorney for the board back in, I suppose, August of 2019, he had said this was something that we might want to address eventually once we were kind of set with our bylaws. So this may be a thing we postpone for a year, or if the board's ready to do that now, we can address that now.
Yeah, so by way of background, we intentionally did not put in the 2/3 provision and put in a majority provision because we figured we were new at this and we might not have yet a comprehensive set of bylaws, and that we should give ourselves as much flexibility as possible to get the structure that we want. And therefore, we had a provision in there making the bylaws changeable relatively easily. And to put the traditional 2/3 would make it harder. So the question is, are we now at a stage where we're familiar enough, we're comfortable enough, we know what we want to do and how we want to do things, that we should go to the traditional and say that the bylaws can't be easily changed and make it 2/3? Or do we want to punt on that, knowing that we do an annual review so we could look at it, next year too and decide if that's the time? I don't hear an overwhelming support for change at this point. Shall we leave it? Drew?
I'm fine leaving it the way it is.
Okay. Brendan?
I'm fine either way, but
I'm fine either way. But I think that we're clear on what we're doing. So 2/3, I may lean towards more in favor of.
Okay. Andres?
I agree.
Agree with which?
To leaving it as it
Leave it
is.
as it is?
Yes.
Okay. Jamel?
Yeah, I'm down with leaving it as well.
All right. And Todd, I think that it's great that you brought that up to remind us. And, if you'd put kind of together a package for your annual review sessions and make sure that 2/3 question gets presented again next year.
Absolutely.
because next year it might be time.
Okay.
Okay. We'll leave it for the time being in this working draft that will be presented again. Okay. Any other suggestions on any changes to the bylaws or the rules? Anything else that we need to look at that we haven't talked about or thought about yet? All right, well, I think we got it. I think we're in good shape, and I think the next meeting that's held, except when we talk through, you know, that one issue having to do with speaking at the meetings on the reports, we can just deal with briefly, and that one issue that we can spend some time on, and so everybody, you know, if you think about it and you know, get any insights from other folks, and then we can make a recommendation on that, and then we can tee that up for the board's in-depth consideration as well.
I have one question. Thank you, Mr. Sweeney. In Article 11, it talks a lot about public buildings. And are we using the word public buildings just to be understood that is metro buildings?
I think to be clear, we should just say metro buildings, or
okay,
metro owned or metro public, whatever. If whatever the requirement is that metro has,
okay,
maybe we use whatever their language is.
All right. So in Article 11, under community education involvement and public comment, it says the board will hold its meetings in public buildings. And so we need to change that in Article 11 in the bylaws, and we need to, it's written in there multiple times. So Todd, if you could make note and change where it says public buildings throughout the county, and then it says public buildings throughout the community, and then it says public buildings for its regular meetings and open public forums. So we need to change that provision.
Well, I guess the question is, do we have to have all of them that way? I mean, you know, if we have a community meeting, do we have to have all our meetings, or do we have to have noticed meetings? Do we, you know, if we just go out and meet with people, you know, as kind of a hearing session, do they have to be in public? So I wouldn't make it more restrictive than the law requires.
Okay.
So I'd say just be careful every time you put it in.
Okay.
And
that's fair.
And make sure, because, you know, obviously board meetings and formal committee meetings, yes, but maybe there's ways to do other things where, you know, there's a better venue.
Gotcha.
As you know, we've had problems with, you know, what is electronically accessible to,
right,
if we have to broadcast or whatever. So
right, and this one also has a provision in there that it's compliant with the ADA. So we do have to be careful.
Yeah. So I wouldn't make it more restrictive than it has to be. Okay.
Ms. Ross, I saw your hand up.
Yes, I just wanted to bring up that for us not to forget, if the public buildings have access to being able to be broadcast.
Right. Okay. So Todd, did you take note of Article 11 so that we can make whatever changes we need to make?
Yeah, I've got that.
Okay, cool. Thank you.
Mm-hmm.
Okay. Anything else? Any other business?
Nope.
All right. Then we shall be adjourned. Thank you, everybody. Oh, Todd, I guess you should send out another calendar for the mid part of February.
Okay.
And set it up. Those will obviously be some committee changes, but
right
from there. Okay.
Yes, sir.
And I just want to remind the public that our board meeting is Wednesday which is the 27th at 4 p.m. So whoever's watching this meeting, if you want to join us on Wednesday, we will be live at 4 p.m.
Thank you, everybody.
Thank you.
Thank you, Mr. Sweeney.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.